the committee, as constituted, is not competent so as to confer jurisdiction as per the Electoral Code of Conduct. It's a straightforward thing. It arises from the Act, and it arises from the Code of Conduct itself, second schedule, Rule 15. The Commission shall set up Electoral Code of Conduct Enforcement Committee, which shall comprise of not less than 5 members of the Commission, and shall be chaired by the member appointed by the chairperson. The Commission may nominate a member of its staff to be the secretary of the committee. Of course, it is now chaired by a member appointed by the chairperson. Of course, the Commission has appointed the secretary to the committee. But until the Commission is comprised of not less than 5 members of the Commission, the jurisdiction under the Code of Conduct second schedule cannot crystallize. Article 50 of the Constitution is very clear that every person has the right to have any dispute that can be resolved by the application of law decided in a fair and public hearing before a court, or, if appropriate, another independent and impartial tribunal or body. Body here can as well refer to the committee, the enforcement committee. And so the first and second respondent is entitled to a fair hearing and an application on the law. It means the inference in Article 50, sub-article 1, means that first and second respondent is entitled to protection of law, and that a tribunal or body properly constituted would apply the law. The law here is the Elections Act, and schedules to that act is the second schedule. And Rule 15 is not only clear, but it is mandatory. It is couched in mandatory terms. Shall is used, and sometimes lawyers argue with whether a rule is mandatory or whether it is directional. In this case, we submit that this is mandatory. It is not merely directional. I also know that the article, the Constitution talks about that the tribunal, committee, or body shall not shall not give undue regard to technicality of procedure. I want to submit, Mr. Chairman, that this is not an issue of procedure. This is an issue of substance. It is not out of a regulation. It is out of an act reinforced by the schedule. And so, because it is mandatory, the Commission can only exercise a competent jurisdiction were it composed of not less than 5 members of the Commission. And so I submit summarily that you don't have jurisdiction, really respectfully, as constituted, and that this complaint as filed may not proceed before this committee as it is. Thank you very much.
Is compliant that the committee or this Code of Conduct Committee as constituted has jurisdiction to entertain and make a decision, and a binding decision on this matter on 2 fronts, Mr. Chair. The first front being, if we address ourselves to the Constitution, Article 250, sub-article 1, the Constitution gives nobody. Each commission shall consist of at least 3, but not more than 9 members. What is the import we get from this? It means that even the drafters of the Constitution, in their wisdom, knew that there will be an occurrence of this nature when a commission will have vacancies but the actions of the commission will continue, and it has continued, Mr. Chair. When we look, the commission has held by-elections in Ugenya, Embakasi South, and Mogotio constituency. So Kibra by-election is the fourth after this occurrence, and we have several county assembly wards elections that have been held. And also it will be informative if we address ourselves to the case of Isaiah P. Watt Kagwoni versus the Independent Electoral Boundaries Commission and the Attorney General, where the court found that the three commissioners, the Iebc was well constituted to carry on a by-election. And by carrying on a by-election or a parliamentary election, what it meant was these are some of those functions that the court meant by saying it is constituted to carry on these functions. And then again, we cannot dismiss the current complaint that is subsisting to the chair on technicality. Does it mean that if that relation is not there, violence will continue unabated just because the relation is not there? I think the doctrine of necessity will come into play. Thank you.
Yes.
You want to say something?
Yes.
And maybe there's also the Katiba Institute case 2018.
Yes.
I believe touched on the same issue, that you are conversant with it.
Yes.
But if not, maybe just say what you want to say.
Yeah, both cases, with a lot of respect, Mr. Chairman, do not apply in this matter. I have read the facts of those cases. These are not addressing the Electoral Code of Conduct Committee. What we're having right now is not the commission. What we are having now is the committee, which is defined in the second schedule. The committee means Electoral Code of Conduct Enforcement Committee. Now, that is a committee which has jurisdiction conferred to it by law. In fact, you then find in your regulations themselves, and I thought I had the regulations here. It is very instructive that the regulation says that the commission can delegate some of its powers to the committee.
Which regulation?
Yes, the general regulations. You have general regulations here. These are the citations here are the elections general regulations, rules of procedure on settlement of disputes, and specifically 14, Rule 14. Despite provisions of these rules, the Commission may delegate to the committee the power to settle disputes filed under these rules. Committee here means the Electoral Code of Conduct Enforcement Committee. It means, therefore, that the law has envisaged a distinction. There is the Commission, but when it sits as a committee, it is a committee. And that is why the regulations make a distinction that it can delegate to the committee. And so what my learned friend is talking about is the commission. We are not talking about your power. I have not come this morning to talk about your power to hold the elections. No. I have not come to dispute your power under the Constitution, even to operate as independent commission. No. I'm not talking about the commission. I'm talking about a committee which is a quasi-judicial function under the law, which must locate its jurisdiction in some part of the law to be able to proceed. That is one. But number two, just to respond to him, is that the functions of the commission and the functions of the committee, even when they are done by the same people, the moment you wear the hat of the committee, you are wearing a different hat. When you wear the hat of the commission, it's a different ballgame altogether. And so I want to invite you to find those two decisions to be distinguishable and actually not binding, and dissuade you to follow the principles there. You see, the last, as I wind up, jurisdiction is everything, and I am sure the commission, you are aware of several decisions in the Supreme Court, in the court before, began by
it used to be the Court of Appeal.
The Court of Appeal,
yes.
Justice Nyarangi.
Yes.
Jurisdiction is everything in law. If you don't have it, you just lift your pen respectfully and bow and say, well, you would have wished to dispense what my learned friend calls justice about electoral offense and so on. But if you don't have the law that allows you to do it, well, you just find yourself unable. And it is not true that there is no regime, legal regime in Kenya that deals with violence and electoral malpractice. There is the DCI. There is.
Now you're going beyond.
No, I'm responding to that bit that he's saying.
Okay.
You see, he said that are we going to have violence? Are we going to have acts of criminal violations and so on?
Yes, okay.
And I'm saying that there are a lot of institutions that can well and are well adapted to deal with these cases. There is criminal procedure. There is the penal code. There is a raft of all laws that are penal in nature that can deal with this. So you do not have to be persuaded just because my learned friend is advancing the theory that then if you are a commission, you must be responsible to enforce the commission. Yes, you should. But if you don't have that power, you, with a lot of respect, just lift your pen and bow.
Yeah.
Thank you very much.
We had to sit down and come up with a ruling. So this is the ruling on the first and second respondents' notice of preliminary objection dated 18th October 2019. The first and second respondent filed a notice of preliminary objection dated 18th October 2019, stating that the Electoral Code of Conduct Committee is not competently constituted as to confer jurisdiction as per the Code of Conduct, as per the Electoral Code of Conduct. The Electoral Code of Conduct Enforcement Committee is established under paragraph 15 of the second schedule of the Elections Act, number 24 of 2011, to hear and determine complaints of violations of the Code of Conduct ascribed to by parties to an election, as governed by the provisions of Section 110 of the Elections Act. It is instructive to note that the rules of procedure for settlement of disputes of 2011 cited in respect of Article 88(4) of the Constitution and Section 74 of the Elections Act applies to the Dispute Resolution Committee, which operates under different structures as governed by the law. The Code of Conduct Enforcement Committee is a creature of the Commission. It cannot exist independently of the Commission. It derives its legitimacy from the fact that the Commission is properly constituted. Indeed, the question as to whether the Commission is properly constituted or not has been a subject of intense litigation in court. In the High Court at Nairobi, Constitutional Petition number 2012 of 2018, Isaiah Biwot Kangonyi versus Iebc and the Honorable Attorney General, the court made a finding that in terms of the provisions of Article 251 of the Constitution of Kenya, 2010, the Commission is properly constituted. As it were, the article aforecited provides that the minimum member of the Commission at 3, that should be minimum number of the Commission at 3 members and maximum at 9 members. The Honorable Judge in the case under reference decreed that the mere fact that some commissioners resigned from the commission does not in itself invalidate the composition of the commission. It's therefore legal for the chairperson and the 2 members of the commission who are in post to sit and discharge the constitutional and statutory mandate of enforcing the Electoral Code of Conduct. While it's not in doubt that the commission and the Electoral Code of Conduct Enforcement Committee are distinguishable as 2 different entities, the committee remains a creature of the commission. It's worth noting, as held in the Katiba case, that the issue of quorum is a matter of common sense and construction depending on the total number of commissioners appointed at any given time. It is the total number of commissioners in post that would determine the quorum of the commission, and in this case, a quorum of any committee that would be appointed by the commission. As was canvassed in the 2 cases, it's to be appreciated that the lack of quorum in the commission has been occasioned by vacancies that cannot be attributed to the fault of the remaining commissioners. In any event, the chairperson of the commission can only establish committees of the commission from the number of commissioners appointed or in post. Notably, Section 7.3 of the IBC Act further provides that the commission shall be properly constituted, notwithstanding a vacancy in its membership. In light of the findings of the courts, it's observed that the provisions of the Constitution on the legitimate state of membership and quorum of the Commission to conduct business has been settled, and as such, Rule 15 cannot assail its jurisdiction. Against the above background, the Electoral Code of Conduct Enforcement Committee is thus properly constituted and legally seized of the complaint filed before it for hearing and determination. The committee makes the following orders. 1, the preliminary objection dated 18th October 2019 is hereby dismissed. And 2, there shall be no orders to costs. This is the ruling of the committee signed by the 3 of us, and it will be availed with the parties.
Thank you very much, Mr. Blunt.
Most of blood, Your Honor.
Mr. Chairman, with a lot of respect, leads us to one other hurdle that we must bring to your attention. It is an issue both of law and on procedure, constitutional law and procedure. You see, Mr. Chairman, Article 50.
Do I understand that you are raising another objection? Or?
Yes, this is an objection. We were not, it was not foreseeable that we could put this in writing because we had put the preliminary point on jurisdiction. We were of a considered view that the jurisdictional issue would be disposed of first. And so it is not possible that we could have put that in written or served the other side, because we have just been seized of your decision. And we do not want to waste the committee's time. We also do not want to ask for an adjournment. So if you please, we can canvass points of law which may amount to objection.
I believe that having given the ruling on jurisdiction, the most appropriate thing to do is proceed with the complaint. And if there are any issues that you may have, then they can be canvassed in the complaint.
This is touching the complaint.
Yes.
But it is an issue which goes to the root of the complaint itself. It's not on jurisdiction.
Yes.
But it touches on the complaint.
And it's not an adjournment.
No, it's not an adjournment.
Okay.
No, it's not an adjournment.
Then I would suggest we proceed with the hearing of the complaint. Then you can respond by way of.
No, the point you are making is that
yes.
The complaint as it is before you, the nature of the complaint as it is before you, and the evidence that we hear, because I just heard my friend say, introduce people to be witnesses and so on. And I was going to say that it would be in order that the respondents became aware of the nature of the evidence beforehand that is going to be laid before the committee. It is constitutional.
Okay.
Yeah, that is the point I was trying to raise. But you will have discretion either to agree with me or to decide as you may wish after you have listened to. Yes. You see, we have made representations. We wrote a letter. Actually, yes, we have written a letter which is canvassing some of these things. So we are not surprising the other side, and we are not also surprising the commission. These are issues which we have put together, and we can validly go through them.
So then the issue is, can we deal with them during the hearing? Because I believe you are referring to a letter which was written to the commission, and I don't know whether you want to mention any particular aspects of that letter.
The only issue we are raising here
Yes.
is, you see it is in paragraph 3 and 4. First of all, this was a short notice, a very short notice, but we have passed there, and we are not pursuing that anymore. We are here at the end of the day.
Yeah.
But the question is, the charge itself and the summons itself are defective. So far as, and we have put it here on paragraph 5. So far as we are able to respond to the allegations. The allegations are general, they are unclear, they are vague, they are generalized, and so on. But the point I wanted to tie it with, that we call for your decision, is the fact that it therefore violates the constitutional right of the first and second respondent. Because the first respondent in Article 50 is entitled to know the case against him. And I was just going to lead us there, because then that would make you make a decision whether you want to allow the first and second respondents to know the evidence beforehand and interrogate that evidence, for example, without necessarily leading to an adjournment. Because I was going to refer you to Article 50, and I was going to say that Article 50, which your members are very conversant with, paragraph 1, but specifically paragraph I, let me put it in context, that every person has the right to have any dispute that can be resolved by application of law decided in a fair and public hearing before the court, or if appropriate, another independent impartial tribunal or body. But 2, every accused person, and this really is an accused person because the consequences are punitive, every accused person has the right to a fair trial, which includes the right, and J, to be informed in advance of the evidence the prosecution intends to rely on, to be informed in advance, and 2, which is very important, to have reasonable access to that evidence. Reasonable access may mean, in the very least, a statement of some form of information about the evidence that is going to be laid before you. It is a constitutional right that my clients can legitimately raise. Now, Mr. Chairman, you will peruse the documents that are before you, the summons, and particularly the complaint which you have. It is referring to information in the media. I think I just have information in the media, and particularly it is also referring to something called some video clip. We are here and we do not know what it is we are going to meet, whether we are going to see some video electronic information, whether we are going to see pictorial information, whether the information will be oral or viva voce, we do not know. That's number 1. Number 2, I have it here. I was just trying to find the one which I highlighted. It was here. I just wanted to illustrate. That's the problem with pages. When you need them, they don't come to you. This is the letter which the
I don't know how long you want to make representations on, because you are coming in by way of PO again, but without saying so.
Yes, I can't call it a PO, really.
Yeah, what you are saying ensure that you don't have the evidence, you don't know what's going to be presented by the complainant.
Exactly, and more than anything else.
Yeah.
Yes. One minute. Just let me finish my thought process.
Because we don't have luxury of
nobody
time.
has the luxury of time.
Yes.
But again, rights of constitutional rights of parties is paramount. We cannot clean over them. The point is that there is information that is coming before the committee, and without discussing about whether the notice is short or long, that kind of thing, my clients have a right to know the information which is before them, which they have not known. And there is the regulation which you just looked at, the regulations, procedure and settlement disputes. It is applicable even to this committee. That is how the application part of it says that it is applicable. And that rule has shown exactly how that complaint should be worded in terms of Form 1. It has not been complied with. All those information are not there. So it is very legitimate for somebody to be able to raise that kind of thing, to be able to respond adequately to the complaint when they are raised. My learned friend Edwin Sifuna wants to reinforce the arguments that are put across. Just allow him 3 minutes if you don't mind, Mr. Chairman.
From what we are seeing happening here in this commission, I remember very well I was in this very same boardroom facing similar charges in the Embakasi South by-election. And even in the face of overwhelming absence of any shred of evidence, your commission proceeded to fine the ODM party 300,000 shillings.
Mr. Sifuna, I'll cut you short. And I think as a matter of procedure, if we move the manner which you want us to move, we are not going to make headway. I want to believe that if you have any point, it has already been made by Mr. Kajwang, and we are not here to look at an appeal of our own decisions, which you have made in the past. Yes, yeah. So
you should allow me to
so if you have any point, just make it.
And you have kept us in your boardroom for 2 hours, but you will not allow us 5 minutes to make our point.
I will allow you 1 minute to make
commission,
you make your point.
The first point of departure before your legal affairs director writes to a party forwarding a complaint is to satisfy itself. The commission should satisfy itself that that particular complaint is in accordance with the rules. The point that the senior TJ Kajwang is making, if you look at the rules of procedure on settlement of these disputes, and he has referred you to specifically Rule 8.4 on what should constitute a proper complaint before the commission, whether it is a concise statement under oath of the ultimate facts constituting his cause or causes of action. That is where you should begin. Is it a concise statement under oath before it is even admitted? Is there evidence that has been supplied to the commission and supplied to us so that we are able to respond? So that the letter that was addressed to you by Senior Honorable Otiende Amolo is laying those issues before the commission, and we want a decision. Is the commission satisfied that there's a proper complaint before it? And number two, have the rules been complied with? Is it proper notice to the parties? What are we supposed to be responding to? Are we going to interact with this evidence in this boardroom today? Or do we have a right under the Constitution to interact with this evidence prior so that we're able to respond to it? And that's what we're saying.
Thank you.
Yeah, thank you. Counsel for the complainant, do you have anything?
Yeah, I think I'll make a point in a minute and then I pass it over to my colleague. First of all, Chair, one, we are listening to the letters that is foreign to us.
Okay. Sorry, you may need the mic.
Sorry, Mr. Chair, I'm saying, first of all, we are addressing a letter from our friends, the respondent, who are saying there is a letter. We are not aware of the letter. We are not aware of the content. So therefore, we have not been served.
Two, there is the old equity adage. Those who come to equity must do so in clean hands. The respondents, both the first and the second respondent, they just served us a few minutes before we came here with their response. But when they come here, they want to claim more right in following procedure than they have already done. They did the same with their PO, but we graciously accepted to continue for the interest of justice, for the interest of a free and fair election, and for the interest that we want to make sure that whatever is going on, there is finality. But when we go in circles, I think we are defeating the essence of it. And then again, they have a right to cross-examine the witnesses we are talking about. I'll allow my colleague to say something. Mr. Chair, if I got the respondent advocate correctly, if indeed they are questioning the charge sheet that was prepared by the commission, the first thing they should have done is to do a preliminary objection on that particular issue or seek an amendment of the same. Mr. Chair, we cannot have a whole day of doing objections because one limb of the preliminary objection has been dismissed. Now they seem to introduce another PO by the backdrop of addressing this issue. Mr. Chair, if anything, we are now lost. We don't know the issues we are addressing because we are supposed to come here for the hearing of this particular complaint. But as it stands, we do not know in what realm and under what principles exactly we are addressing these particular issues, Mr. Chair. And we seek the committee's direction to proceed with our complaint, which we are ready to do.
Let me give guidance to the proceedings. Yes, we have received the letter you are referring to, Council for the respondents, and we believe all the issues raised in that letter can be canvassed during the hearing of these proceedings. And the committee will make a decision.
I think this is a
let me finish. Let me finish.
Just go ahead and find us whatever decision you want to make because you don't want to listen to our...
Mr. Sifuna, you are out of order. You cannot misbehave in this. You have subjected yourself to this committee and you must sit and listen to what I'm saying. So we proceed with the hearing. Counsel for complainant. You said you have some witness?
I will allow my colleague.
Yes. I'll make such remarks.
Well,
yes, yes. Yeah.
Mr. Chairman.
Yeah.
Mr. Chairman, objections will never end as long as there is a legal basis for making them, and I have one to make right now.
Is the other side aware of the objection?
No.
Yes.
Now it's on the evidence. On the evidence. I have an objection before this witness is led to give evidence, and I think I'm entitled to raise that objection.
You don't even know the witness.
No, I don't have to know the content.
Yes.
I can raise an objection based on law if I think that the witness is not competent to give the evidence.
Okay, let's see what they have. I don't know the witness is calling. Yeah, I'm sure you don't know him.
No, whichever witness.
Yes.
Whichever witness.
That's the whole point.
It is simple, Mr. Chairman, that you have ruled, and I will abide with it. But the rules here tells me that before a witness is able to give his testimony, there must be a written information on oath. And I do not know, at least I've not been served, of any affidavit on oath. So whatever this witness wants to testify on, I don't even want to know his name. But before he can even tell us his name, the first thing we must be satisfied with, and the law is here. The law is here, it is Rule 8 of the rules, that there must be information on oath, not just a complaint. So, Mr. Chairman, that is a substantive matter which touches on impartiality of dispensation of justice, that this committee, as a tribunal with quasi-judicial function, must make that decision. It's absolutely right. It's a constitutional issue. It is a statutory issue. I think the commission must make a decision whether there is information on oath with which the witness may be led. Even if you refuse that I should not see it beforehand, even if that is not an issue, is there information under oath that the witness is able to be led through? Thank you, Mr. Chairman.
Mr. Chair,
Yes, Council.
one thing is for sure, our witness is going to be sworn in before he starts to give his evidence. And I don't know what better definition of testimony under oath than one which he's going to do, because he's going to raise the Bible if he's a Christian, and he's going to be sworn in, and that is the definition of a sworn statement, Mr. Chair.
Am I reading a different law? It says a complaint shall state, amongst other things, and the information and identity, blah blah, a concise statement. Can this be anything oral? In F, it says a concise statement under oath of the ultimate facts constituting his cause or causes of action. Can it be oral? It must be a written information. It must be under oath. And let me just reinforce that this election procedure on settlement dispute applies directly to this committee. I have said so because the committee here is defined as the conduct of enforcement committee, and the application part of it, Mr. Chairman, so that we don't abuse the rules here. Application of the rules, that is Rule 4. It says these rules shall apply to disputes or complaints arising from so many other things, but in C, violations of code of electoral conduct. So how can we have regulations which applies to the proceedings of this committee, and then we take a witness without a written information under oath?
Yeah, precisely. The point I'm making is very simple. Because of limited time, I would have thought that we would proceed with these proceedings and finalize. And if the charge is defective, I thought it works in your favor. Yeah, I mean, you are counsel.
No,
you should know this.
I don't have to have any favor of anything.
I mean,
need favor of law.
Yes.
I just
If the law has not been followed,
yes,
I think that it's very clear. The committee will make a decision.
But how do we entertain? How do you, with what jurisdiction would you entertain a Kenyan out there to speak before you if he does not have a concise statement under oath? That is the point. You only have a jurisdiction to entertain a person who speaks to you with the information beforehand under oath. And so what you need to do, I do not stop them from giving whatever evidence they have. But the first question you want to ask them, that witness you are calling, where is the evidence? Where is the affidavit under the hand of a commissioner with which he can be led? That is all we are asking. We are not stopping him. I suppose perhaps the complainant himself can give evidence, because I don't see that in the rules. The complainant can. But when he introduces a witness, that information must be concise and it must be under oath.
Very well. You want to say something before we make another ruling from
Mr. Chair,
Mr. Kajwang's objections?
Mr. Chair, I believe we can take the committee's direction, and in the event the respondents are disgruntled, the same law gives them a right to appeal, and there are mechanisms to do the same. But we'll take the committee's directions, and we still insist that we're ready to proceed.
Yes, but you also need to remain inquisitorial, or what kind of...
Yeah,
you need to remain.
okay. Now, you know, we are not seated in the High Court where we have to follow completely the rules, but nevertheless, you have raised an issue which the committee will have to look at. It's now, what time is it? 1 o'clock, 1:20, 1:16. We shall retire and can convene at 2:30 for purposes of making a ruling on this matter, on the issue of which you have raised.
Can we make it at 3:30 or 4:30? Going by the precedents that I've seen.
No, this time 2:30 the commission will be here.
2:30 means 2:30.
2:30 means 2:30. Yeah.
In that intervening time, learned counsel is here, the witnesses are here. it is not difficult for them to use that time to prepare sworn statements and serve us so that we bring ourselves under the rule. But for me to hear the commission chair saying we don't have to follow the rules, then why are we here?
Mr. Sifuna, you like twisting things.
That's what you say.
What we are simply saying is that we come at 2:30. If any party wants to file anything and serve, that's up to them. And let me be very clear. It's up to the parties to file their documents. It's not for us as a committee. Now, if even the party has not filed and followed the rules, that's their problem. Yes. Thank you.
It would seem like I was right.
You knew what you placed before us.
Anyway, we are here now. Let's make progress. Yes, before we adjourned, the first and second respondent had made representations, and the committee will proceed to make the following ruling. The first and second respondent filed a notice of preliminary objection dated 18th October 2019, stating that the Electoral Code of Conduct Committee is not competently constituted as to confer jurisdiction as per the Electoral Code of Conduct. The Electoral Code of Conduct Committee considered the preliminary objection and made a determination dismissing the objection with orders to proceed to hearing and determine the complaint. Counsels for the first and second respondents proceeded to raise additional objections on point of law with the argument that the complaint is defective for lack of adherence with the procedure governed by the rules of procedure for the settlement of disputes 2011, with particular reference to Regulation 8 that states the manner of initiating complaints. They further disputed the introduction of witnesses by the complainant in a manner contrary to the provisions of Regulations 15 of the Rules of Procedure. Counsels for the complainants argued that they were ready to swear their witnesses under oath and submit oral evidence. Counsels for first and second respondents maintained that Rule 8 and 15 requires that the complainant institute a proper written statement under oath. The committee has addressed its mind to the issues raised and observes that the rules of procedure of settlement of disputes, that's legal notice number 139 of 2012, provides Rule 4.1c. These rules shall apply to disputes or complaints arising from violation of the Code of Conduct. Rule 8.4f, the complaint shall state a concise statement under oath of the ultimate facts constituting his cause or causes of action. Rule 15, Sub-Rule 2, a complaint under Sub-Regulation 1 shall be accompanied by statements of the complainant and his witnesses, all of which must be under oath, as well as other documents to support the complaint. The committee notes that Section 15, Subsection 6 of the Code of Conduct provides that the committee shall not be bound by the provisions of the Criminal Procedure Code or the Evidence Act in its proceedings. Further, the rules under Rule 16.2 empowers the committee to issue administrative guidelines for purposes of expeditious, efficient, lawful, reasonable, and procedurally fair settlement of disputes. In facilitating expeditious procedures, Section 15.6 and Regulation 16.2 inform the Commission's regulations of its own procedures. It's worth noting that the Commission's mandate to address violations of the Code of Conduct cannot be strictly restricted to the procedures highlighted above, case in point, violence, damage of property, and actions causing bodily harm. Indeed, as previously presented, the Commission, in exercising its powers, can institute investigations and issue applicable sanctions and penalties. In making its determination, the Commission is aware of the provisions that provide for undue regard to technicality and judgments pronounced on the same, but in this particular case, reference is made to existing procedures already gazetted to guide in management of disputes and violations of the code. Notwithstanding the above, the Commission acknowledges the issues raised before us, and in the interest of fair hearing and administration, makes the following decisions. 1. The complaint herein is dismissed for want of compliance with Regulation 8 and 15 as relates to filing, save that the complainant shall be at liberty to file fresh complaint as per the provisions of the law. All parties are hereby warned to desist from any acts of violence. And 3, there shall be no orders to costs. That's the ruling of this committee, signed by the 3 of us. Thank you.
I'm most obliged, Mr. Chairman. Are we able then to get the copies of the rulings, and most importantly, the proceedings? This is my first time appearing before you.